Welcome to the International Academic Conference of Law and Politics, held in Istanbul, Turkey, 2014. An International Answer to Capturing Corporate Criminality, authored by Mohammed SALEEM TARIQ. The agenda for this presentation is twofold. Firstly is to explore the impracticalities of derivative fault-based models for capturing corporate criminal liability, such as the identification principle or the vicarious principles. Secondly is to discuss the benefits of organizational fault in the field of corporate criminal liability. In the international sphere, there has been a unified consensus against the recognition of a distinct corporate personality, and, as expected, have no such doctrine in place. Some countries have opted to impose administrative penalties, emphasizing the dichotomy between corporate entities and the corpus of criminal law, as developed to fit the psychology and human characteristics for human defendants. In light of this, in and around the world, there have been episodes of corporate accidents that have resulted in grave and unaccounted for injustice. In continental Europe and many other countries, the corporate veil has been lifted. And alarmingly, on this side of legislative research and development, nations have retired with several exhaustive models for capturing corporate criminal liability. A revolutionary jurisprudence that shelves awkwardly in the most recent of archives as a deterrent instead of what it should be, and that is an active, punitive measure against a corporate criminal. The reality of modern-day decision-making in multinational corporations equally requires a fault-based model which focuses primarily on their corporate culture. This presentation shall evaluate the success of the corporate culture model advanced by the Australian Criminal Code Act 1995 in a comparative analysis with other international models of corporate fault. The importance and viability of the corporate culture model shall be emphasized for its sound applicability in honoring the idea that those multinational corporations bear responsibility towards global social justice. The identification principle. In the following case of H.L. Bolton Engineering and T.J. Graham, Lord Denning used literary devices to liken a corporate entity with the human mind and body. The following case of Tesco Supermarkets and Natras established the directing mind and will principle. The identification doctrine paved the way for achieving corporate accountability against transnational corporate activity in the realm of corporate criminal liability, but has done so unsuccessfully, and this is why. The directing mind and will insulates corporations simply by delegating their managerial activities down the hierarchy of its geographically widespread structure. Using this mechanism leaves only flatter organizations susceptible to having criminal liability imputed from its directing mind and will. Canada. Expanded identification. One may notice that the threshold for imputing corporate fault from the directing mind and will has been lowered to mid-level managers who, while not responsible for setting corporate policies, are on the other hand empowered to implement them. The enthusiasm, however, soon deflated when the approach was not able to capture or prosecute a company or its 3 employees in the face of 26 dead miners. The Bill C-284 actually drafted, interestingly, a corporate culture model, perhaps anticipating that the expanded identification doctrine may have provided horrific and unsatisfactory results such as this, yet disregarded it in favor of the latter. The United Kingdom. By virtue of the Corporate Manslaughter and Corporate Homicide Act 2007, the senior tier of management must have played a significant enough role in the management of corporate activity. The level of difficulty involved with prosecuting companies is exacerbated by onerous causation requirements. This in effect narrows the scope for locating senior management for negligence-only offences. It has therefore proven itself to be an inadequate model of corporate fault for many high mens rea offences. South Africa. Vicarious liability. The codified position for the doctrine of corporate criminal liability in South Africa disregards what rank the employee may be for the purposes of imputing fault onto a corporate body. As a consequence, the net of liability is ambiguously wide for high mens rea offences. Thus, it could be the case that fault does not lie with the company. The vicarious criminal liability approach does not give room for the organisation to change anything within its day-to-day runnings simply because it cannot control, monitor or anticipate what the interests of its employees may be to avoid criminal liability. As a result, it has been argued that a strict liability approach runs the corporate criminal liability regime under vicarious criminal liability clothing. The United States of America. Respondit superior. Novara offered a resolution to the codified vicarious criminal principles adopted in South Africa, namely, to require the company to have benefited by the employee's action rather than for the employee's action to have furthered the company's interest. Novara's approach has been a running precedent, in fact, under the federal laws in America. The doctrine of respondit superior not only dismantles the boundaries between civil and criminal laws, but it also tears down the full element which makes an act a crime in an over-accountable way against conceptually fundamental principles of criminal law. The doctrine should capture corporate fault, not individual fault, in order to hold a corporation accountable for where its interests are different, but it is in a better place to compensate. Australia. Organizational fault. Inside an organisation filled with management, employees and agents, the Australian Federal Criminal Code has identified corporate fault through the corporate culture. Sullivan contends in a sense that individual intention flows downwards from the corporate culture. This culture does not therefore represent the corporate's mind or requisite culpability. Braithwaite, however, says that group thinking forms something completely different. It forms individual intention, which is embedded in the corporate culture, a culture that represents the surplus within the organization or the company's own mind. A conventional thought that has established the world's most sophisticated model of corporate criminal liability. There is a fear that a company may have unwritten rules and develop showcase policies to avoid criminal liability. The erroneous task of implementing an inadequate program to run this daily or at potentially hazardous costs eases the tension for Wiseman. Kaval points out how unlikely it will be for the company to have supported a criminally unwritten rule at or before the time of the commission of offence. The worries with the corporate culture model, however, do not outweigh the impracticalities and violations of the models of fault employed by various other jurisdictions. The theoretical simplicity of imputing the requisite mens rea onto a corporation through its top echelon quickly trended the primary mechanisms for subsequent fault-based models in several jurisdictions. In doing so, this inadvertently narrowed the scope to work outside of a nominalist approach and develop an inherently practical model for capturing true corporate fault. Straying from this model alternatively leaves legal hands with a difficult choice of either setting an arbitrary limit as to who may act as a company, or have no limit at all and either give up all attempts at corporate criminal responsibility or suffer the injustices of vicarious liability. The surety is this: we cannot retract a doctrine of corporate criminal liability in pursuit of universally accepted objectives, including deterrence, retribution, and justice, and we cannot remain with an impractical model of corporate fault for the present. The answer is a move towards a realist-based system which recognizes criminality against the psychology of a corporate defendant through its very own culture.